Breaking news, something huge is unfolding right now in America's legal system. It could change everything you thought you knew about your rights. The Supreme Court has just made a critical move in the Duncan versus Bonta case, the explosive battle over California's magazine ban. And what's happening behind the scenes will shock you. This isn't just another court update. It's a turning point that could redefine the Second Amendment and set off a nationwide storm. What if I told you that this decision could expose deep political motives, legal contradictions, and hidden agendas that the mainstream media refuses to talk about? Stay right here, because what I'm about to reveal will leave you questioning who's really in control. Before we dive in, make sure to smash that like button and subscribe to this channel. It's crucial for the YouTube algorithm to recommend videos like this to more people who care about truth, justice, and transparency. Your subscription doesn't just help me, it helps keep important stories like this alive, stories that powerful voices don't want you to hear. And don't forget to drop a comment below telling me what part of this case shocks you the most, because I promise, by the end of this video, you'll have plenty to say. We're going to break down how the Supreme Court's latest decision could either protect your rights or strip them away piece by piece. We'll uncover why this ruling has sparked outrage across the nation, from gun owners and constitutional scholars to politicians who see this as a test of America's freedom itself. And trust me, you'll want to stay until the very end, because the final revelation in this case is something almost no one is talking about, and it could completely change the direction of this entire debate. Buckle up, the truth behind Duncan versus Bonta is more controversial than anyone expected. And by the time we're done, you might just see the Supreme Court and your rights in a whole new light. 1. Let me begin by warning you. What unfolds in this case is not just legal technicality, it is a battle over the very essence of gun rights and state power. The Supreme Court is now being drawn into the heart of the dispute over California's ban on large-capacity magazines, those holding more than 10 rounds, under the landmark case Duncan versus Bonta. This isn't simply a magazine law fight, it is a crucible for how far states may limit arms accessories under the Second Amendment, using historical analogs, regulatory traditions, and public safety arguments as their weapons. 2. To understand how we got here, let's step back into history. California first enacted a ban on large-capacity magazines in 2016 via Senate Bill 1446, effective July 1, 2017, and later folded it into Proposition 63, which added criminal penalties and stricter enforcement. That law quickly became a lightning rod for legal challenges. Plaintiffs, Virginia Duncan and others, sued, arguing that the ban violates the Second Amendment. Over years, lower courts granted, reversed, stayed injunctions, remanded in light of Supreme Court precedent, and bounced between district and appellate courts. 3. A pivotal moment came in New York State Rifle and Pistol Association v. Bruin, 2022, where the Supreme Court declared that courts challenging gun restrictions must apply a text, history, and tradition test rather than the old tiered scrutiny approach. That shift forced the Ninth Circuit to re-examine Duncan under the Bruin framework. 4. Under Bruin, the Ninth Circuit convened en banc, meaning a full complement or subset of judges, and considered whether a magazine ban is consistent with the nation's historical tradition of firearms regulation. In March 2025, the Ninth Circuit delivered its en banc opinion. It upheld California's large-capacity magazine ban, reversing a previous district court decision that ruled it unconstitutional. 5. The Ninth Circuit gave 2 independent reasons. First, it held that these magazines are not arms or protected accessories in the sense of the Second Amendment, meaning that constitutional protection does not even extend to them. Second, even assuming they are protected, the court said the state showed a sufficient historical tradition of regulating dangerous arms components and preserving public safety to justify the ban under Bruin's second step. 6. But that ruling was not unanimous. For judges dissented. In dissent, judges like Nelson, Bumate, Van Dyke, and Ikuda raised sharp objections. The majority misinterprets the concept of arms, ignores the functional necessity of magazines for a firearm to operate, and fails to find valid historical analogs to justify a flat ban. Judge Van Dyke even produced a video supplement in which he handles firearms to argue conceptually that accessories like magazines should be seen broadly as part of arms. 7. After that decision, the California gun rights community and allied organizations moved swiftly. The California Rifle and Pistol Association, CRPA, filed a petition for certiorari to the U.S. Supreme Court, asking the justices to take the case. They argue the court must resolve this split on whether magazines count as protected arms or accessories, and whether blanket bans violate Bruin's framework. 8. Meanwhile, a stay of the Ninth Circuit's mandate was requested or supported, halting enforcement of certain judgments while certiorari is considered particularly to protect individuals who lawfully acquired magazines during Freedom Week or prior lawful possession. The stay ensures that enforcement doesn't prematurely erase rights before the Supreme Court has a chance to weigh in. 9. But the controversy deepens. Some critics argue that by treating magazines as non-arms, the majority is effectively allowing states to strip away accessory components of arms, eviscerating the functional reality that a gun without a magazine is useless in many modern contexts. Others warn that if the Supreme Court declines to hear Duncan, lower courts and states may proliferate sweeping magazine bans, knowing few will challenge them successfully. 10. Another flashpoint. The Ninth Circuit's reasoning leans heavily on historical analogs, but opponents say the court twisted or misread historical regulation to justify a modern ban that has no real precedent. The dissent accuses the majority of intellectual overreach. This gets to the heart of Bruin. You must match modern regulations with historical policies. The critics say California's law is too novel, too sweeping, with no genuine 18th or 19th century counterpart. 11. This case also touches on Fifth Amendment takings arguments. The plaintiffs asked whether banning possession of magazines without compensation is akin to taking property under the Fifth Amendment, a constitutional compensation requirement. The petition to certiorari includes that additional question. 12. More broadly, Duncan versus Bonta sits in the crossfire of a larger movement. Many states have magazine or large capacity restrictions. 14 states and D.C. already limit magazine capacity in some form. If the Supreme Court accepts and rules broadly, it could reshape magazine regulation nationwide. 13. Some potential outcomes loom. The Supreme Court could deny certiorari, decline to take the case, leaving the Ninth Circuit ruling in place for the Ninth Circuit states. Or SCOTUS could grant certiorari, hear argument, and issue a decision defining how Bruin's test applies to magazines, possibly striking down or limiting magazine bans. Either path has enormous implications. 14. For gun rights advocates, the stakes are existential. If SCOTUS affirms that magazines are not protected or that blanket bans are permissible, states could push even stricter limits or bans on other accessories. Conversely, a win could check states' power to restrict accessories and reaffirm robust protection for self-defense tools. 15. Legal scholars are watching also how SCOTUS handles the procedural side. How strictly will the justices police lower courts' historical analogs? Will they reinstate a more tailored, functional view of arms rather than a cramped textualist approach? Will they draw clear boundaries preventing runaway regulation? 16. Also controversial is the judicial behavior. The Ninth Circuit's internal procedures, how it constituted its in-bank panel, and whether the judges who assumed senior status should sit again, have drawn criticism. Some see the Ninth's procedural rules as too lax, allowing shifting panels to rehear cases unpredictably. 17. Furthermore, the video that Judge Van Dyke released as supplementary dissent handling firearms and magazines blurs the line between opinion and advocacy, prompting debate about whether judges should engage in such public forms of argumentation. Critics say it politicizes the bench. Defenders argue it helps illustrate technical points. 18. As the petition for certiorari now awaits the court's decision, the question is, will SCOTUS bite? The petition was filed August 2025. The justices have discretion, and signals from prior denials suggest they're watching lower courts before picking a case at the right moment. 19. If SCOTUS grants cert, we may see oral arguments in the next term and a decision possibly by mid-2026. That decision could deliver a blockbuster ruling clarifying magazine status under the Second Amendment and curbing or affirming state bans. 20. Now, here's the revelation you've waited for. What many don't realize is the Ninth Circuit's majority opinion explicitly invites future expansions. It suggests that states might regulate or ban other firearm accessories like buffer tubes, magazines, or attachments. Under similar logic, if they can argue they are optional or non-essential. In short, if the court doesn't rein in this reasoning, today's magazine ban could be a Trojan horse for sweeping future bans on the tools that make modern firearms effective. And that is the final, shocking twist this case may trigger for all gun owners a precedent, not just for magazines, but for the architecture of permissible arms regulation. 21. As you watch what comes next, think about the consequences. Will SCOTUS affirm that even components critical to a firearm's function may be treated as non-protected? Will states push further, knowing the road is paved? Will gun rights advocates lose ground piece by piece, one accessory at a time? 22. So here's what you must do. Subscribe to this channel and hit that like button right now, so that when the Supreme Court rules, you'll be among the first to get my analysis. The algorithm will favor videos with traction, and your support ensures this kind of content reaches smart, concerned viewers. And below, comment, what part of Duncan versus Bonta most surprised or alarmed you? Was it the notion that magazines could be declared non-protected? The historical argument? The dissent video? 23. Don't go away, stay until the very last second of this video, because that final revelation, what I just shared, the danger of accessory regulation creep, matters more than any single ruling. It's not just about magazines, it's about whether states can slowly dismantle arms rights under the guise of public safety. 24. In the upcoming segments, we'll walk you through A. The Bruin test and how it applies. B. Side-by-side comparison of majority versus dissent arguments. C. How this case compares with other magazine challenges in states and circuits. D. What to expect if SCOTUS accepts. E. Predictions for future accessory regulation. And finally, F. What you can do as a citizen, advocate, or gun owner to stay informed and engaged. 25. This is a turning point not just for California, but for the nation's constitutional framework on self-defense, regulation, and judicial power. Stay alert, dig deeper, and be ready, because the outcome of Duncan versus Bonta could echo for decades. So don't forget to subscribe, like, and leave your comment about what shocked you most about this decision, and I'll see you in the next video.